He's really excited. So far, he's been
Good.
it's in a great
In
place.
Chicago?
In a great place, Chicago.
Good afternoon, all. I think we'll begin. I'm Sam Rushforth, the Dean of Physical Science and Health at the College of Science and Health, and we'd like to welcome you to our first symposium speech of the year. And we have a fine inaugural speaker this particular day. And we're going to, many of you are aware that there's quite a controversy going on about whether or not genes should be able to be patented, and especially human genes. And we have a company in Utah, Myriad Genetics, that's involved in the thick of this, and in fact is involved in some litigation on this particular issue. So we have, this is so interesting, we've invited a speaker today from Myriad. His name is Benjamin Jackson, he goes by Ben. Ben did his undergraduate work at UCLA in molecular biology, molecular genetics, and then went to law school at BYU and has been at Myriad for 2 years, a couple of years?
3 years.
3 years. And so he's one of the unusual guy who has not only a lot of scientific background in the very field that he's been representing Myriad in, but he also is a patent or an attorney with lots of experience in patenting. So he has been intimately involved in Myriad's defense of the gene patenting debate, and I'm personally delighted to be involved or to be able to hear this seminar today. So, Pat, would you come up? And Ben, sorry. That was good, right? We have, I know you're Ben because we have a small gift for you with your name on it, and it's a wonderful pointer.
Excellent.
And if anybody goes to sleep on you or starts snoring, you can get them.
We'll do that.
There you are.
Thank you.
We also have a small, we made posters for distribution on campus, and we made one for you. So
excellent. Thank you.
You're more than welcome. So thank you for coming.
Thank you. Thank you, Sam, for the introduction. Thank you, Louise, for setting this up. And thank you all for being here. So this is definitely a controversial topic that I'd like to talk about today. It's something that we at Myriad have not taken too much time to come out and speak about, but we're given the high-profile nature of the controversy these days, we've decided to go ahead and come out and kind of do a little bit of education, a little bit of advocacy. I won't deny that I have a position here and I have an interest in the outcome of this debate. So just a quick little introduction on the title here. You know, I say the great gene patent debate, the side you haven't heard. First of all, you'll notice that gene patent is in quotes. I do that because initially and even to this day, I take a little bit of umbrage with the term gene patent because, as you'll see and as I'll discuss a little bit more, we don't really patent genes as they exist in the body. We feel that there is a very significant technical and socioeconomic difference between patenting a gene and patenting an isolated form of the molecule that makes up that gene. So we'll talk a little bit more about that. And also I talk about the side you haven't heard because generally speaking, at least what I've seen of the coverage of the controversy, one side has been heavily covered and heavily discussed, and our side not quite so much. So let's talk a little bit more about that and let's get going. Of course, I've got the standard disclaimer. Statements made by this presentation represent opinions of me, the author, and do not necessarily reflect the views of Myriad Genetics. So here's a quick outline of what we're going to talk about. I want to go a little bit into the economics and how innovation really works in this country and largely how it works in the world, how innovation gets to the end user. A little bit on patents, some background. I'm not sure how much any of you understand or know much about patents. A little bit of a molecular biology primer. I'm not sure how many people are studying molecular biology. If you're not, you should be. It's the way to go. And then we'll get into the ACLU suit and some of the arguments. Just kind of a fun little aside. you'll notice this thing here. I did not make up this little logo, nor did Myriad. You know, we don't create logos for our litigations. But I found this on a website that has, it's a blog about genomics and law and society and how those converge. And they've actually created their own logo for their discussions about our litigation. That's how big it is. I mean, I'm guessing that the litigation that's going to come about with, well, I'm sure that is inevitable with BP will not have its own logo. Or if it does, it won't be that pretty. Let's do a little bit of Innovation 101. And this might be particularly interesting to some of the professors here and those who expect to or hope to be in the business of science someday. This is kind of how I see, oh boy, the top line is a little cut off. If we can, is there any way to adjust that? Well, we can, it says Innovation 101, follow the money. And this is kind of how I see the paradigm of how basic research gets into the hands of the end user. A lot of it starts in the universities, might even start here. And those universities have their own funding, that's true, independent sources of funding. But based on the Bayh-Dole Act and the tech transfer movement from universities that started, boy, I can't believe I forgot the year. I think it was the mid-'80s, or was it early '90s that Bayh-Dole came in. Universities are allowed to patent their inventions. And what typically happens is a startup company will be created, and that startup company will then go on to develop and commercialize that product or that invention into something that can actually be used. Often what was discovered in the university is not in a usable form yet. It's just sort of a basic discovery of something like that. So the startup company is heavily dependent upon patents. You'll see that patents actually factor in several different places here. Getting private funding to help support the startup company often is, it's almost exclusively a patent question. Do you have patents? Why is that? Because if you're a little company that's going to be going up into maybe an established market, and you want to go up against a bigger company, you need exclusivity. Otherwise, the larger company will just raid your product. So patents are key there. Once the startup company has caught on, the product really works, it's something that has a market, you'll see a lot of market building, expansion, profitability. These are all, again, supported by the exclusivity provided by patents. Hopefully, or ideally, the money, the additional profit margin that is provided by patents will allow for investment into new products, which then might result in more patents, more money going back into market building, research, and of course, all through this, royalties are funneling back into the university to fund more research and more discoveries. And ultimately, because patents are limited in their term, within 20 years or less, the competition can copy whatever you've got, that's the way the patent system was designed, and that's one of the purposes, is to get these things out there, give somebody exclusivity for a little bit of time, and then let everybody else jump in. So let's do a little innovation case study. So you've got some university researchers, they think they can solve a medical problem that's been a big problem for a while, and so they start working on it. And they're competing with a bunch of other groups that are much better funded. These university research, they try to get some government funds, but the government turns them down because the government is already funding some of the bigger, more well-known groups. So the researchers get their own private funding. Well, the private funding is basically contingent upon the idea of, yeah, we'll give you the money, but you better get a patent out of it. The researchers make a significant breakthrough, get the discovery, and they beat all of the other groups. And some of the losing groups, and a lot of other people, complain about the patents, but don't bring a legal challenge. Now that's significant in this story. A small startup company is created, and additional private funding comes in based largely on these pending patent applications now. The company spends a couple years developing and launching the product. Pretty soon after the product is launched, the company is sued. It's kind of an immutable law of commerce. If you've got a good product, it will be copied. And you will be a target of a suit. But both of these actions settle very early. They never even get close to a courtroom. And everything's kind of quiet for a while. The company keeps going, builds the market. The company invests hundreds of millions of dollars, employing up to 1,000 people to further refine the product. For example, some independent researchers discovered a new aspect of this product and basically said, you know, it needs to, we think that it should be modified in a certain way. And the company says, boy, we think you're right. Works on it, figures it out, improves the product, promotes the product. Now this is, you've probably already guessed that I'm talking about Myriad genetics, but raising patient and doctor awareness. In the realm of molecular diagnostics, this is one of the key aspects that I'd like to get across, that this is something a lot of people don't think a lot about, but you know, Myriad Genetics has spent over $200 million over the last 15 years or so raising doctor awareness about hereditary breast and ovarian cancer alone, and that's only one of our products. We develop, or this company develops and launches new products. In the case of Myriad Genetics, we actually had a pharmaceutical division. So the money from the molecular diagnostics was funding pharmaceutical research. Unfortunately, our big Alzheimer's drug, which we were really excited about, failed in its phase 3 clinical trial. We really hoped, we wished that had worked out, but it didn't. But I mean, that's a good example of reinvestment of the money. And if it had worked, it would have been a boon to sufferers from a very serious disease. And the company actually operated at a loss for its first 10 years. Obviously, the company is Myriad. Here's a little bit more about us. The discovery of the 2 genes that are associated with hereditary breast and ovarian cancer. Talking about mutation, so 90% of all cases of HBOC are attributable to mutations in the BRCA1 or BRCA2 genes. And this represents roughly 7 to 10% of all diagnosed breast and ovarian cancer. So that's a pretty significant amount. There's 200,000 plus new cases of breast cancer every year. Ovarian cancer is quite a bit less, but still it's like 40 to 50,000 a year. And 7 to 10% of those are hereditary. So we got our patents from the patent office on isolated BRCA molecules and methods. These are laboratory methods of determining the status. And we launched BRCA-analysis testing. This is our flagship product, in which we determine the sequence of these genes and determine whether the patient, usually a woman, has an increased risk of breast or ovarian cancer due to mutations in this gene. And this test has become the standard of care. It's reimbursed very broadly by health insurance, which is another unknown aspect, I think, of this debate. Here's where I get into a little bit more of revealing my bias. I feel like Myriad has been an outstanding steward of the technology that we've been entrusted with. And I feel like we've done a great job of getting it out there and getting women tested. And in my mind, it's the story of how the patent system is supposed to work. Big upfront investment, big risk, big payoff, that's true. Reinvestment of the money, new discoveries, new products, and in about 5, 6, maybe 7 years, the patents go away anyway, and anybody can jump in. So, however, I think that because of the new ACLU lawsuit, there's a potential for a tragic ending. And what I see there is what I've got right here. These 15 years, hundreds of millions of dollars in investment. Only a couple of years after we've become a profitable company. We were running at a loss till just a few years ago. And there's a bunch of parties who want to jump in and offer a cheap, competitive product. Based on the exact same theories or rationale of challenge that they raised and could have sued us on 15 years ago, but they chose to wait. Here's kind of a theme that can go through here. The top says, you can't see it, but it says Myriad, poster child, or bad apple. And I kind of leave this up to you to decide. I obviously have my own opinion. But there's a lot of rumors out there about how everybody knows that Myriad aggressively enforces its patents. As I mentioned before, actually that's not true. We sued one lab one time, And that was, 12 years ago. And it settled quickly. Myriads, a lot of people say Myriad's enforcement has chilled basic research and test development. We'll talk more about that later. In reality, there's very limited enforcement of our patents, and there's very limited enforcement generally of any, quote, gene patent. We'll talk a little bit more about that. And I like to say that we're the poster child of the patent system in molecular diagnostics. So let's take a quick step back and go over some basics. That was a very long intro. I admit that. Let's go back to some basics of patent law. And it's a centuries-old challenge. How do you get innovation into the hands of the public? Sometimes the discovery is in itself already a downstream product, but that's very rare. Usually, the eureka, aha discovery happens in a lab somewhere, buried in some science building, and it needs years to become something that is actually usable for the consumer. And in our case, the healthcare consumer, which is everybody, right? And so for centuries, governments have used patents as the way to incentivize innovation. And I can't stress that enough. I mean, every country, every industrialized country on earth has a patent system, even the People's Republic of China. A communist country has a patent system. It's relatively new, you know, they're coming along, but they have a patent system. And for 200 plus years, the US patent system has proven that patents incentivize discovery, investment, and commercialization. So here's a little bit more, let's go into the patents a little bit. What can be patented? Section 101 of the Patent Act says that any new and useful invention can be patented. So, well, what does that mean? They talk about compositions of matter, articles of manufacture, processes, things like that, and they say any new invention. Now, the courts have limited that a little bit. They've said, well, we didn't really mean, or Congress didn't mean any new invention. If it's an abstract idea, a mathematical algorithm, a phenomenon, or a law of nature, then that's not patent eligible. We're going to say that that's outside the realm of what's patentable because, well, there are a lot of different rationales that have been expressed by the courts, but generally the idea is that that is just in the realm, it's in the public domain. It's something that was there in nature, it was already there, you didn't invent it. You know, there are a lot of different ways to put the idea, but that's the basic idea. But those have traditionally been construed as very narrow categories of what cannot be patented. Everything else. So the default position is always patent eligible. Then you turn and look, well, you know, is this a law of nature? If so, then maybe it's not. So here's a quick summary of that. Patents are the proven way to incentivize discovery and delivery, more importantly, of technological innovation worldwide. And an invention is patentable unless it's clearly excluded. And in my mind, exceptions should be very rare. If the default position is something is patent eligible, then the onus is on the challenger to explain why it should not be patent eligible. So opponents of gene patents claim that these patents are an exception to the established norms, i.e., patents are not needed to incentivize discovery or delivery, and isolated nucleic acids and the related methods are in this narrow class of excluded matter. Just like Atlas, I believe they have a very heavy burden of persuasion there, because again, I feel that the law clearly makes it that the default position is patent eligibility. Not just patent eligibility for inventions, but that patents are a good way to incentivize inventions and that they're necessary. Okay, let's take yet another step back and quickly do a little molecular biology primer. Now, this is not just a molecular genetics 101. This is relevant to what we're talking about here. Just out of curiosity, who here is a student in some sort of molecular biology field? If you want to raise your hands. Boy, not as many as I expected. If others are undecided on their major, I would recommend it. I mean, this is a very exciting field of endeavor and science and knowledge, and I mean, I really lucked out that I get to be a lawyer and yet still learn about cutting edge science in the life sciences. that's a pretty good way to go. It's a good gig if you can get it. But definitely I would encourage you to look into the life sciences. Okay, enough of that. So the central dogma of molecular biology says that there is DNA in our cells. That DNA molecule is transcribed into an RNA molecule that's kind of a mirror image of that DNA. And then that RNA molecule is translated into a protein. Now those proteins go off and do most of the functions of the cell. They catalyze chemical reactions, they form the skeleton of the cell, they transmit information between cells, all sorts of things. So proteins are kind of the machinery, and I'm going to slip into one of the things that I like to call gene patent opponents on, but I'll do it myself. DNA is more of the footprint, or the blueprint for the machine, right? You'll see why I kind of don't like that terminology later, but as much as it's inconvenient when we're talking about gene patents, it's pretty accurate. So DNA and RNA are large molecules comprised of linear units that just repeat different linear units. Okay, so they're very large. Human cells have 46 chromosomes made out of DNA, protein, and a bunch of other things, and these are enormous. Chromosomes range between 250 million and 60 million base pairs. Wait, can I go back actually? Yeah, so the base pairs would be these right here. We represent them with the letters A, T, G, and C. They're not letters, they're actually molecules. A refers to adenine, T to thymine, and it's just a shorthand way of representing a large molecule. This kind of shows how the DNA is coiled up into chromosomes. You know, you start with this kind of clean-looking molecule, it gets wrapped around proteins, and it goes on to become a chromosome. Mutations are changes in the DNA. So let's say that this is what we call the wild type. This is what the normal sequence of this molecule should look like. There should be a C there that's paired with a G. But in some people, there's a mutation, sometimes called a single nucleotide polymorphism if it's at one position. And instead of a C there, there's a T all of a sudden, and that T pairs with an A. Now if that is in a critical position in the molecule, it can be very important. It can cause a very serious disease. For instance, sickle cell anemia is caused by one mutation in one amino acid of a protein. And it's a very serious condition. Some mutations, as I was just talking, lead to detectable changes in the person. That's called the phenotype. So the mutations would be the genotype. What you see or what you can detect outside the person would be the phenotype. For about 20 years between 1980 and 2000 was what I would like to call the era of gene discovery. That's when single genes associated with diseases were tracked down amongst the vast milieu of DNA. These genes were tracked down and discovered and sequenced, and people deciphered their structure, right? And examples, of course, are the BRCA1 and 2 genes. That's what Myriad did along with the University of Utah. CFTR gene is associated with cystic fibrosis. I forget actually what, I think this is Canavan's disease, maybe. HFE is hemochromatosis disease. So these are this is how people found genes before the Human Genome Project. Now in the early 2000s, we finished the Human Genome Project when the entire genome was mapped. And at that point, there's really not much more discovery of genes anymore because you know the whole sequence. I mean, you can still we're still teasing out the function of different portions of the genome, but for the most part, the era of gene discovery is over. Now here's the title here, sorry, it says, how do you sequence a DNA molecule? It's not like reading a book. It's a very involved technical laboratory process. You isolate the DNA from the cells because there's a lot going on in a single cell. There are a lot of different proteins, a lot of large and small molecules floating around working to keep that cell functioning. And one of those, or 46, well, yeah, 46 of those molecules are the chromosomes, right? So you got to break all those out, separate them out from all of the other stuff that's going on in the background. Then you'll do, typically what will happen is you'll do what's called the polymerase chain reaction, and you'll amplify or enrich your sample with just the portion of the molecule that you want. And what you're really doing is you're creating synthetic copies of that molecule. It's no longer the actual molecule that you pulled out of the cell. It's now a synthetic copy. It's still DNA, but it's not the actual same DNA. It has the same sequence, but it's not the same molecule itself. Just for perspective, the BRCA genes, if you were to compare the size of the BRCA gene molecules with the whole genome, it's about 1 to 5 million, right? So it's a very small portion of the genome that we're looking at here. And you use oligonucleotide primers as part of your polymerase chain reaction, PCR reaction. And then you use a sequencing machine to use often fluorescent labels and things to determine what is the actual sequence or structure of that molecule. And I like to use the word structure a lot because I think that it's more helpful to think of it in terms of structure rather than sequence. Sequence a lot of times implies just a sequence of letters. And that's how it's often presented. That's how the structure is presented. That's how we often think about it because it's just an easier way to look at it. But I'd like us not to lose sight of the fact that this is a physical chemical molecule with a structure. And when we say sequence, we really mean the structure. So here's another question. What is a gene patent? So now we're kind of really getting deep into what is the controversy all about. Myriad's BRCA1 claim is pretty typical of gene patents. It says an isolated DNA coding for a BRCA1 polypeptide or protein. This polypeptide having the amino acid sequence set forth in CKD number 1. So what it's really saying is we're claiming an isolated form of the molecule that can be translated into this protein and perform whatever function it does. Here's an important point. This does not cover genes in your body by definition. An isolated DNA. The DNA that is functioning in my arm right now is not isolated by definition in the patent. So that's an important distinction because I think it's often lost. The opponents of gene patents like to make a lot of hyperbolic accusations and sort of create ethical quandaries that aren't there, as far as patenting people, violating the 13th Amendment against slavery. That's not happening. We are not patenting people here. The patent only covers molecules that are either artificially produced, such as in the PCR, or removed from their natural environment, such that, like I was talking about, isolating the DNA from the cells and breaking them down into smaller pieces. And as I was talking about the Human Genome Project, there's not a whole lot in the way of new gene patents today because it's all pretty much out there. We've also got claims to the laboratory process of detecting mutations and predicting disease risk. And this is really what Myriad does. We don't just tinker around, look at the genes and think, wow, that's pretty cool. No, we get a patient's blood sample, we sequence her DNA itself and say, you know what, she's got a mutation that cuts off the protein halfway through. The protein doesn't work anymore. She has up to an 80% risk of breast cancer in her lifetime, which is compared to, I think it's like 5% in the general population, something like that. Pretty important information to know. So just a reminder of the patent quid pro quo. The patentee discloses what they've found rather than keeping it secret, which is one other way to protect your intellectual property. You get a limited period of exclusivity in which you can reap a pretty substantial profit to recoup that investment and probably get some money more. And it provides incentives for commercialization. Now let's get to the lawsuit. I know that sounds like, where are we going? Why aren't we talking about the ACLU lawsuit? Well, now let's talk about it. ACLU and that's the American Civil Liberties Union, and the Public Patent Foundation, also called PubPat, brought a lawsuit against Myriad claiming that our patents were invalid. But not just that our patents were invalid, I mean, that was their legal challenge, right? So there are legal issues that are discussed heavily in the case, but there are also kind of what I would call policy issues, socioeconomic issues. And the legal issues are, are isolated DNA and RNA molecules and methods involving these molecules patentable? Or are they a law of nature? Are they a phenomenon of nature? What are they? Can they be patented? That's a purely legal question, right? Are they new and useful? That's also a legal question. All these different things. But most people who've heard about this controversy either don't care about the legal issues or understandably don't want to take the time to learn all of the background. And that's definitely understandable because it is a tortured past of this issue of is something a law of nature or not. What it really comes down to is what I call the policy issues, i.e. what's wrong with gene patents? Not are they patent eligible, but are they bad? And if they are bad, why? And that's really what has been predominant in the media blitz against gene patents. And I don't blush at saying media blitz because it has been. Every major news organization has carried something about this controversy, and for the most part they've been contra. They've been against gene patents. And for the most part, the discussion has focused on these policy issues. Are they bad? So the title here says, what's wrong with gene patents? And again, from the very beginning, many scientists opposed gene patents, predicting that they would stifle research, hinder patient access, and that gene patents are unethical. And there's a certain, I'll admit, there's a certain visceral appeal to this, not my genes, they're not patenting my genes. This logo was taken off of the ACLU website, just so I could show it to you and we could sort of comment on it, right? Do not patent my genes. You can see that it's got this humanistic appeal of nobody should own something of mine, right? And that's something to think about, There's also been, like I mentioned, some kind of fanciful imaginings of what a gene patent could cover. One philosopher wrote a book in which he basically postulated that a gene patent would be infringed by reproduction, which is absolutely untrue. You cannot infringe a gene patent by having a baby. Trust me. And then today's opponents bring up basically these same arguments. Again, I think that the timing is not very ripe. It's basically 15 years later, and we've built our market now. So, first question, do gene patents hinder research? A little bit of background. I mentioned the Bayh-Dole Act. It's basically to encourage downstream development of university technologies. So the universities can patent their inventions and then out-license them to either an established company or start a startup company. And then that company can take the ball and run with it and develop the product and hopefully get the technology out to the public. One thing I'd like to mention that sort of falls between the cracks in a lot of this gene patent debate is a very important court decision called Mady v. Duke. If you get a chance, you might want to look it up. It was a major shift in the law. Before 2005, it was pretty much understood that academic researchers were exempt from patent infringement because there's a common law exception to patent infringement called the research exemption. And before 2005, everybody pretty much understood this to apply to university researchers. In fact, Myriad filed its patent applications in 94, 95, right? Well, 10 years later, the law changed on us. We didn't do anything about it. We didn't advocate any sort of a change in the law, but all of a sudden, the court came out with a decision that basically said university research is no longer exempt from patent infringement. And there was a lot of discussion as to why, and I mean, I'm not here to discuss the merits of that case, but the basic idea that the court had there was that universities make a lot of money off of their research. They use it in recruiting, they use it in getting grants, and they have a very strong commercial interest in their research, and they've ceased to be sort of these esoteric, purely academic, pure knowledge institutions. Yeah, there's some validity to what the court was saying. I don't know that I fully agree with the court's decision. I certainly, I'm not thrilled about the result of the decision and the effect it's had, but again, I'm not here to really talk about that case. So what are the allegations as far as gene patents hindering research? Profit-driven corporations will shut down research labs. And remember, we're talking about research labs here. And if not for patents, scientists would freely exchange information and materials. So these are the allegations. The facts, in my view, are very different. Here's an article you might want to look up. It's by Timothy Caulfield in scienceprogress.org. He talks a lot about these allegations, and even though he has at times been critical of gene patents, he's calling out some of the other opponents and saying, you know, let's be intellectually honest here. It doesn't really hinder basic research. Thousands of gene patents, very little litigation. There's an article by Chris Holman in Science magazine. Just kind of 4,000 gene patents, only 31 lawsuits since 1987 is what he found. Compare that to pharmaceuticals. There's almost 1,300 lawsuits in 4 years between 2000 and 2004. So clearly, we're on a different scale of how much litigation is really taking place on gene patents. Now, Walsh, also in Science magazine, found that researchers really don't care about patents. They don't worry about it. I like this quote. Of 381 academic scientists, none were stopped by the existence of third-party patents. And I like this. Academic competitiveness and material transfer hang-ups are the primary barrier to the free flow of scientific information. In other words, it's not patents. It's trying to get your materials from a fellow researcher, well, a colleague at another university. That's what they found to be the major impediment to scientific research. Of course, there's the question of open versus paid access in medical journals. For example, in most journals, you have to pay to get access to the articles. You know, anyone see a little bit of an inconsistency when you know, some of the medical establishment criticizes gene patents as being an impediment to the flow of scientific knowledge, yet in the same moment they're charging me $35 just to read an article. Think about it. Do Myriad's patents hinder research specifically? We did a little research for our court case, and we found that 18,000 researchers produced over 8,500 scientific articles on the BRCA2 genes alone. Actually, won't go into this. Table's a little bit complicated. Don't have enough time to go into that, but suffice it to say that patented genes don't suffer from a dearth of publications. Let's put it that way. And Myriad has made over 20,000 submissions to the Breast Cancer Information Core, which tabulates mutations that are associated with HBOC, more by far than any other contributor. Do gene patents hinder patient access? The allegations are that a patent monopoly makes the tests too expensive, and that test quality will diminish because there's no competition, right? The facts. What does that stand for? Secretary's Advisory Council on Genomic Health and Society, I think. I don't remember actually. But it was a committee convened to advise the Secretary of Health and Human Services on the issue of genomic patents, genomic tests, and things like that. And they came to the conclusion that exclusive and non-exclusive tests cost basically the same. So BRCA analysis testing is undoubtedly somewhat expensive. It's about $3,500 to get the test done. But a comparable test that's offered by 100 different labs on a non-exclusive basis will be basically the same price. In some cases, even more expensive. And also, as to the test quality, Myriad's test is recognized as the gold standard in publications all over. I don't know if I have time to get into this. The ACLU included some patients as plaintiffs, individual patients who are saying, I can't get the test because I can't afford it. Now those particular patients have specific facts surrounding their scenario that might explain why they were not able to get the test. But basically, the high cost of healthcare is a national problem. That's not due to exclusive molecular tests. I mean, look at Myriad. We have a dedicated force of 150 customer service representatives who their job is to shepherd patients through the insurance reimbursement process and the testing process, and to help doctors get all of this done, to help doctors wade through the morass of insurance and reimbursement. I mean, certainly if there are inefficiencies, one could make a pretty strong argument that it's on the insurance side and not the provider side. Compare this with drugs. New cancer treatments cost tens of thousands of dollars every year. Myriad's test, one time $3,500 that can save hundreds of thousands over the life of a patient. Beyond, so those are the money savings, beyond, of course, saving lives. And Myriad has programs for patients who cannot afford testing. In fact, we give out free tests for uninsured patients who meet certain financial criteria. Are gene patents necessary? That's kind of another question. You know, a lot of people say, well, the discoveries are going to be made anyway. Why do we even need a patent? I mean, look, there were 10 other groups. I don't know if it was 10, but 10 other groups fighting to be the first to discover the BRCA gene. So if Myriad hadn't done it, somebody else would have. And there's some validity to this point in terms of academic research done at universities. That's true for the most part. I mean, it's kind of the 1,000 monkeys working at 1,000 typewriters for 1,000 years writing the works of Shakespeare. It'll happen. The question is, the real question, is what about actually delivering that product to the end user? Once you make the discovery, I'd argue that's not even half the battle, really. You need to commercialize, you need to develop, and in most cases, you need to go out and market. I mean, a lot of people look at marketing as, you know, Coca-Cola having a big ad in my face everywhere I go. And so it kind of has a negative connotation, same with the word commercialization. But here I mean getting the product out into commerce and out to where people can get it. And that's something that, frankly, private companies are well suited to do. Universities in general and public institutions are not well suited to. Again, I mentioned that Myriad has spent over $200 million in raising doctor awareness and patient awareness. A Duke study found that in molecular diagnostic tests that are not supported by exclusive patents, that investment does not happen. Are gene patents unethical? The allegations are that gene patents cheapen life, gene patents prevent doctors from treating patients, and I already talked about the imaginary problem of reproduction equaling infringement, which it does not, by the way. The facts are different, I believe. Gene patents don't cover anyone's gene in the body. It must be an isolated molecule. No doctor is prevented from ordering the test any more than a doctor is prevented from ordering an MRI because it's expensive. You know, if a patient is uninsured and can't afford an MRI, they're basically in the same position as they would be if they couldn't afford BRCA analysis testing at Myriad. Healthcare is expensive, and that's not really Myriad's fault. Let's put it that, or molecular diagnostic testing laboratories' fault. Okay, kind of closing up here. Who cares? Who cares about the gene patenting debate? Medical organizations have weighed in, patient advocacy groups, prominent academics, researchers, the biotech industry. You can pretty much predict which side they'd be on. Universities, patent law associations, and of course the media. And really, I think the couple of takeaways that I'd like to get across here are what's at stake. And I think it's really the creation, delivery, and quality of medical innovations. Who's going to innovate? The universities, they will probably still innovate. Like I said before, they're going to go through with their research, but they'll have less money to do it. And once it's discovered, who's going to commercialize it? Again, remember that Duke study. Who's going to spend the $200 million educating doctors about what is HPOC? How do you get tested for it? And who will invest in improvements? If everybody's on a level playing field from a competitive standpoint, they will fight to try to get a competitive advantage, but only up to a certain point of investment. Their margins are going to be low, and so they won't have a lot of money available to invest in those improvements. Science and jobs. The U.S. biotech industry leads the world for now. Who knows how that will change depending on the outcome of this controversy. Patient health, and I think this is where our inquiry should really focus. What is the net effect of gene patents on patient health? And that's what everyone has to ask themselves. I've obviously formulated my opinion that it's positive, that the net effect is positive. I can't deny that there might be isolated negative effects, but when you total everything out, take the net effect, and you look at the example of BRAC analysis testing at Myriad, to me it's undoubtedly positive. And that's the core question. I would advocate dropping a lot of the rhetorical discussions and a lot of the, I mean, certainly ethics factors into it, but it's hard to come to a final decision based purely on ethics. And the question of, are you patenting somebody's body part? These are squishy questions. Let's get to the facts. Let's get to the science, the evidence. Is the net effect on patients positive? Ask yourself that question. Go do some research and come to your conclusion based on those facts. And if you do, I'd be happy. Because I think a lot of people are coming to a conclusion without even caring or paying attention to those facts. And personalized medicine is at stake. This is the future of healthcare. Tailoring medicine to each patient, to that patient's genetic, personal, specific genetic makeup. Which drugs will work, which drugs won't. Which patient should have a mammogram every year rather than every 5 years because her aunt and her mother had breast cancer at age 50 or 45. This is personalized medicine, and this is, without a doubt, the future of medicine for everyone. And correlation patents, such as, a mutation in gene X means response to drug Y, that is the core patent protection of personalized medicine, and that's what's at stake here in this court case and in this controversy. And finally, here are your takeaways. If you can get some of these, I'd be happy. But again, don't take this at face value. Go out and look at it. Look at the facts. Try to formulate your opinions on this. Patent laws do not explicitly preclude gene patents. There's nothing in the patent statute that says no gene patents. Okay? So we've got to decide the issue on some pretty murky law. There are complex values and interests here. You've got Myriad and its view as a molecular diagnostics company. You've got patient interests, which are not necessarily in opposition. In fact, I believe that they dovetail well with Myriad and the way that it operates, but some people disagree. You've got the American system of innovation. Patents are the default way to incentivize innovation. In my opinion, court decisions are a blunt instrument. They're a sledgehammer. If the ACLU case at the next appellate level, or even at the final appellate level of the Supreme Court stands, then all gene-related patents will be gone. There's no nuanced discussion of, well, maybe under these circumstances they'd be okay, maybe if they were limited in this way they would be okay. None of that. They're just gone. It's a sledgehammer. Congress, on the other hand, can craft a nuanced solution by amending the patent statute. And they can get feedback from all of the interest holders, all the stakeholders, patients, advocacy groups, molecular diagnostics, doctors. Everybody can go up to Capitol Hill, present the facts, and Congress could use a scalpel, I'd say, as opposed to the sledgehammer, to really craft something that will serve everyone's interests. And again, like I said, the outcome will profoundly affect the future of medicine because personalized medicine is the future of medicine. Thank you for your time. I bet a lot of people have to run off to class. It wasn't that long ago that I was an undergrad, and I know how that feels. But if you've got any questions, if anyone would like to remain and ask questions.
I know a lot of you have classes. If you have to go to classes, why don't you go now? And the group that can stay and ask questions for a while, we'll bear it on for 10 minutes or so, a little longer. So thank you very much, and just catch your questions.
I have a comment and a question. The comment is when you first show your first slide with follow the money, that money eventually, of course, comes from our total medical costs in this country. And this is one of the reasons why medical costs are so high in this country, because we are the country of innovation that does this program. And as we think about lowering medical costs, we have to always include in that debate its effect it will have on medical innovations.
Good point.
Most medical innovations for the entire world come because of this type of system. And the Time magazine, when they did their article about medical costs on the front page, and it's sort of stuck in the corner, they had the little acknowledgement that our high medical costs are the reason that's driving innovation that everyone benefits from. So as we talk about it, we have to think about the fact that we are making these things so they're not going to happen to us. That's my comment. The question is, a couple of years ago, and I think it was Robin Cook, I may be wrong about that, wrote a popular novel addressing the gene patent idea. And in that novel, he raised the question that even though you're dealing with molecules, PCR, making you're dealing with molecules, eventually you follow that back, it comes to somebody's blood that contributed the initial gene.
That's true.
The question raised in that novel was, should that person benefit from the financial profits of their of eventual product that came originated initially with their blood? You know what I mean?
And that's a very good question. And actually, that to some extent, that question was answered by I don't remember whether it was Supreme Court or the Federal Circuit, Court of Appeals for the Federal Circuit case. It's the University of California versus Moore. And that was a case where a cancer patient donated some of the samples, some of the cells from his tumor to the University of California for research. The University of California cultured those cells into a cell line, what we call a cell line of immortal cells that you can just keep around and do research on, because normally the cells would just die. And so then UC started loaning out the samples, started making patentable inventions and discoveries based on those cells. And so Mr. Moore came back and said, hey, where's my cut? I gave you those cells. And he's got some reason to question that, right? I mean, he's seeing how much money is going into the UC based on the cells that he gave them. Now, in that case, if I remember right, and it's been a long time since I've read it, he had signed a waiver, basically signing away all of his rights in that sample. And patients in this type of research typically do that. Now, what patients might want to do from now on is to think a little bit more about that, but also to think about what would the effect be on the rate of innovation and the rate of research if every patient says, I want $5,000 for my blood sample. I mean, all of a sudden, a sample that was $100 covering the patient's time and expenses for going and getting the blood draw is now 50 times the price. What happens to research? Does it grind to a halt? Who knows? But I mean, it's a very good question, and it ends up being answered, I think, by the informed consent document that is signed by the patient who gives.
They don't read anyway.
They should.
I just recently was up at the Moran Eye Center, and in order to get treatment, and a lot different than Mr. Moore, who gave tissue.
Well, I don't know. Maybe it was part of his treatment. I don't know.
For me to get medical treatment, I had to sign that waiver that says University of UConn can do anything they want with anything they take off my body.
That's surprising, because I actually had a liver. That's surprising because I had a liver biopsy recently, and they asked if they could use my biopsy sample to do research, but they didn't.
So many mutations, his sample is very valuable.
They didn't make my treatment contingent upon my assent, though. I'm surprised that was. And they said that we will not treat you unless you sign this?
That they could do anything they wanted with it. And
that's kind of an aggressive approach, I would say.
You know, people just sign those things.
Yeah. That's true. But
it's not an informed consent, because one thing, and that this practice has stopped, is that placentas and all of the things that can be extracted from it at all of our hospitals, these poor little ladies that are, in the middle of labor, find this thing that, sure, you can dispose of this, but dispose doesn't what they're doing is they put it in the bag, and what they don't see is that the placenta material is taken out, sold for a really fairly nice profit, all this stuff extracted and then sold out on the cosmetic market. And you know, and yet the thing that's wrong with what Bob is saying, what has been generally practiced in many hospitals, and I think applies here, is that there's no informed consent. They don't tell you what they're going to do with it.
Well, they should. Under the law, they need to.
You know, when you've got somebody
I mean,
who's labor before they're going to sign anything and not read it.
we had that experience just 18 months ago.
When you come into the emergency room, when you come into somebody with cancer, you kind of have somebody at a very disadvantage.
That's true. That's true.
So I think on that end of it, there needs to be a little bit more disclosure, a little bit more transparency in what's going on with that.
I agree. I agree.
So I understand one of the slides was saying that the patent covers the PCR products and other things as well as the test, but not the actual gene itself. Does that then mean that it doesn't preclude others from getting out samples of their own, doing PCR on their own genes and generating their own test, or is that?
No. Well, yes and no. I talked a little bit about, that's, by the way, if you ever talk to a lawyer, you will never get a straight answer. You'll always get a yes and no answer. But I talked a little bit about the research exemption and how that's been emasculated in the realm of academic research in universities, and that's true. But it remains on the books, as it were, even though it's common law, it's not statutory. And so what that means is that courts have often said that people who are infringing patents because they're doing research, I can't remember the words, but they basically mean for the fun of it, or just to know, that they're exempt from infringement liability. So in the case of someone, I would imagine that in the case of someone who actually has a lab in their basement and can do the test and is just doing it for the heck of it, then I suppose that they would probably be shielded from liability. So there's that answer. But as far as whether they are fulfilling the limitations of the claim on the patent, now remember, a patent sets forth claims, which are little fences, and the fences say, you cannot enter this fence. I own what is right here for 20 years, at most. That's another thing that's lost a lot of times. It's not forever. So that little fence basically says that if you isolate a BRCA gene out of its natural environment, then yes, you are infringing our patent. But if you're doing it just for fun in your laboratory, you're probably not going to be subject to liability because of the research exemption.
You mentioned that if you were to lose this particular court case, that it would lead to a degradation in personalized medicine if genes aren't patentable and you can't profit from them. But in some of your opening remarks, you stated that we now are living in a post-human genome project world where genes will no longer be patentable. So are you predicting a general decline in personalized medicine in the future?
No, and that's very astute, because there are those two aspects of this case. Now, what is widely trumpeted is this issue of the genes. They're patenting the genes, they're patenting the molecules. Molecules are saying to the gene, they should not be patentable. But what's often not talked about, and I probably should have highlighted a little bit better in my presentation, is the correlation patents. The correlation between mutations in the BRCA1 or 2 gene and increased or predisposition to hereditary breast and ovarian cancer, right? Now those patents, I think I mentioned that in my very last slide, I don't know, was those patents are the core of personalized medicine. And those are what are being challenged as well. Let me see, well, whatever. That's what I was basically saying, is that these correlation patents, this is where personalized medicine is going. Does HER2 amplification mean that you will respond to the drug Herceptin? Yes. But, so there's a correlation between amplification of the HER2 gene and response to trastuzumab. Well, guess what? That's the type of patent that's also being challenged in this case. What the opponents are saying is that's a law of nature. The gene, by the laws of nature, tells you whether you will get or whether you have an increased risk of breast and ovarian cancer. So that's a very good question, but that's what I would say, is there is a big challenge to the future of personalized medicine in my mind. But we've got a lot. Who had their hand up first?
I'll go, 'cause I gotta go.
Okay.
So it was one of your arguments is that innovation is spurred on or is better when patents are part of the process, right?
Yeah.
But it seems like the Human Genome Project is the perfect example that that's not the case. Because the amount of innovation that has happened since that, which was, you know, not a patentable information that came to us anyway, seems like that's the perfect example against that argument. Or am I thinking wrong on that?
No, to some extent you're right, and I recognize that when I talked about how some of these discoveries will be made regardless by academic-minded universities. Universities are doing research. I worked in a lab that was doing research on bacteria and trying to find out how the Krebs cycle worked and how one particular enzyme one particular enzyme bound to a particular gene that encoded a protein in the Krebs cycle. Talk about obscure, right? So they're going to do this research. They're going to do the basic research, and the Human Genome Project is one of those cases. It's actually a huge conglomerate of researchers, but they did it. And like I said, those discoveries are going to be made. The question is, how do you get the products of those discoveries out to the people? So
that's the delivery. That's what I said. But you argued that innovation was also part of that.
To some extent,
like innovation.
To some extent, it is.
In the free interchange instead of in the patent process.
Yeah, to some extent it is. But here's a great example within the BRCA context. We were racing against, there are two BRCA genes, right? BRCA1, BRCA2. We found BRCA1 first, filed a patent application, right? Next, we were racing against other teams to find the BRCA2 gene. Now, one of those teams found what looked like the BRCA2 gene and was correct in its structure up to a certain point. But they had left a big chunk off, and they were missing some pieces, right? They filed their patent application. And pretty soon afterwards, we filed ours with the correct sequence. Now, they were not spurred by their patent because actually they wanted to file their patent to block us. They were more of an academic, kind of a public institute. It's the Institute for Cancer Research in the United Kingdom. And just the way that played out, in my mind, that shows that actually the patent corrected what was done wrong by the public institution. Because spurred by the patent, we actually ended up getting the correct sequence of BRCA2. Now that's an obscure example. Who knows how often that's really going to work, but I think it's an example of truth where the patent spurred one company to actually improve upon the discovery that was made by the public institution that was not seeking exclusive patent rights. But you're right, I think that the bigger value of patents is on the delivery. I agree with that.
Two more questions and then we're going to break.
Speaking as a researcher, just to follow up from that, self-correction happens very quickly in the academic environment anyway. Just to say that a company was able to correct something, it would have happened within 6 months anyway.
Could be, though there was nothing in their publication that suggested that anything was wrong. I mean, someone would have to at least suspect that it was wrong.
Well, other people would have gone and looked for themselves. That's very common, particularly for such a hot gene.
It's possible.
People would independently go back and do it.
It's possible, and yeah, I mean that's true. The question is, how long would it take? How long?
That was just half a question, by the way.
Did you have another half? Did you have another half?
The other one, I guess it's a little more philosophical, but to actually specifically claim the use of that sequence out of the cellular context is very broad. Like, I know you're selling us something very specific, but any analysis within a lab will involve that very process. And so while you've sort of sold us something that's highly specific and under constraints and a nice little fence around everything, it's an incredibly broad concept to say any extracellular use or extracellular manifestation of this intracellular gene is patentable. It's still very broad. Why haven't, or probably Myriad has done this, wouldn't it be more appropriate and more legally defensible
to actually say, look at the use, the application of that for this specific purpose of diagnosis of breast cancer. And if you did that, then you'd be a lot more easy to defend. The ACLU wouldn't have had their wonderful day in court, and
they won on that issue too.
The overreach, I think, was done by you initially by claiming such a broad usage, and then if you actually were more tighter and had a claim that more tightly correlated to the technical use of what you're doing, then you'd be a lot more defensible.
A couple of different thoughts on that. I mean, you're right, and the way that patents are usually pursued by sophisticated companies is to start claiming the world, and then eventually you'll get things narrowed down. And yeah, so not that we were claiming the world, but admittedly they are broad claims. No, you're right. You're absolutely right. Those are broad claims. And we do have narrower claims that cover just the correlation, just the test, that type of thing. Note, however, that those claims were challenged as well, and they were also invalidated by the district court under the basically the same reasoning. So that's why I don't want to sound alarmist, but this is the type of thing, these are the types of claims that form the core of personalized medicine in the private sector. And so those are the things that are under attack. As to how broadly our claims cover basic research activities, they could. However, I'd point out that Myriad has never sued a basic researcher, and wouldn't.
That's your choice, right?
Exactly. So that's kind of where I was kind of going with that case of Mady v. Duke in 2005. Up till 2005, it wasn't our choice. It was the understanding that if you were doing basic research in an academic university, you were exempt from infringement liability. So for the first 10 years of our patent applications, that was the state of the law. Then the law changed on us. We didn't change it. And we haven't changed our view. I mean, look, the law changed, and guess what? We didn't sue anybody. So it's a valid concern that maybe other companies wouldn't be as permissive as Myriad as far as basic research goes. I doubt it, though. From a practical perspective, I really doubt that any company would go and stop somebody at the University of Florida from doing basic research on a gene. I really doubt it. I don't see the practical impetus to do it, especially since they're not going to get any damages. What are their damages? So, I mean, there are a lot of practical reasons why in the real world it would never happen. Or, I guess you can't say it would never happen, but I would be shocked. Did we have one more?
Can we ask one more?
Oh, that's the last one, though.
Landon asked two, and we both asked one. I just have a quick question. So if this lawsuit holds, will companies then move to close basically their databases? In other words, I'm assuming Myriad has a database of mutations and risk factors that they have. So will their profit now come from closing all their results rather than sharing them? And they'll just say, well, we have this test. We can also analyze it for you. We're not giving the analysis out unless you pay us for the informatics part of it.
Sorry.
Is that the direction that companies would have to go? Is that the effect of what would happen without a sensible patent law?
I believe so. And you've brought up one thing that I kind of glossed over in one of my slides. I really like this term, though. Kind of the balkanization of molecular diagnostic testing is what we see as a potential risk. Sorry, I got to use my new laser pointer. Well, it's related to the balkanization question, but that if you've got 100 labs fighting for the scraps of molecular testing, and they can each do, say, 100 tests a year, rather than one lab doing 1,000 tests a year, how many of those labs will freely share their information? They certainly don't need to. You know, they're not legally required to. It might be wise, you know, that if their business model dictates it, they might want to, but there's certainly nothing currently saying you must. So you've got data dispersed or balkanized across the country, And if people aren't sharing, and if they want to gain a competitive advantage against other labs, they might not share their data. But with only 10 samples a year, let's say in the context of HBOC, Myriad does, well, I don't even know how many we do. We do a lot of tests a year, right? So we gather a lot of data. Well, guess what that means? That means that we can tell whether the mutation is deleterious, meaning it'll cause a predisposition to breast cancer or ovarian cancer, or not. But if you've only got 10 tests in that year, and let's say only 3 of them actually have a mutation, and those are all 3 different mutations, guess what your report is going to say to the patient? You have a mutation. That's it. Currently, roughly, I don't know, the vast majority, sorry I don't have hard numbers here, but the vast majority of our reports that report out a variant in the gene can tell the patient this is a deleterious mutation. Why? Because we do so many tests, we see so many of the same mutation or mutations of the same type in the same region of the gene, we're able to figure out the clinical significance of those mutations. And again, think about the net effect on the patient. Does the patient want to know that there's a variant in their gene? They don't really care. They want to know whether, she wants to know whether she has up to an 80% chance of breast cancer in her life. Myriad can tell her that. And under this alternate reality of no patents, fewer labs would be able to tell them that. That's what we think. We think it's worked very well.
Thanks very much. Several of you, we can continue this conversation.